You want to find out how close E. Jean Carroll is to getting $100 million from Donald Trump in 2025 alone? Because she has two separate federal judgments rendered by two separate federal juries against him? Because she was abused sexually by him, as two juries have determined? Because she was awarded punitive damages? There was a recent appellate decision in her favor. How does that play into the mix? Well, if you like all of that information and want to know more, and you want to have it explained to you by two lawyers who know what they're talking about, Legal AF After Dark. Take a listen.
Feels like months ago. It really does. But it was actually, I had to go back and check that it was the beginning of the week. This was decided December 30th, 2024, when you look at the cover page, and that's the E. Jean Carroll appeal. I think there's a broader narrative here, though, Michael Popok, because what it shows is when you stare down Donald Trump, when you fight someone like E. Jean Carroll, right? A woman who was strong, who persevered, who was attacked, but she was not bullied to back down. What happened? She's won. She won both of her trials in federal court. And when Donald Trump appealed, this is the case involving the sexual assault and one aspect of the defamation case. There's still another defamation case that she won that's on appeal that will be heard separately. But she won on the appeal. And so it's such a juxtaposition, right, between E. Jean Carroll and what ABC did, what George Stephanopoulos did, when they didn't just obey in advance, they willingly obeyed. They just obeyed, and they gave Trump's library $15 million, future library $15 million, perhaps, so ABC can take a tax deduction by making it payable to a nonprofit. They also paid Trump's legal fees because Donald Trump says it was defamatory that George Stephanopoulos characterized the sexual assault a certain way, and Trump said that because George Stephanopoulos essentially characterized the assault as being genitals versus finger, even though a jury found liability for finger, that's tarnished Donald Trump's reputation. And Michael Popok, what we do here is we read the court transcripts, we read court rulings. You know, we sometimes offer opinions, but I go right to the documents, right? When I teach my law school classes and I mentor law students and undergrads, you know what I say? A good lawyer needs to have a hard ass. And what I mean by that is you got to sit down and you got to read. And if you don't want to read, if you want to just give me your opinions about what you think the code says or what the opinions say, that's not what this profession is about. You just have to look and read the words of the opinions, the footnotes, the concurring opinions, the dissenting opinions. So let me just read what the federal judge wrote, then we'll turn quickly to the appeal. Let me turn it over to you, Michael Popok. This is what Judge Lewis Kaplan, the federal court, ruled before Donald Trump appealed it, but this is what the judge ruled. So think about this when you go, ABC really settled this? The jury did not award Miss Carroll more than $2 million for groping her breast or her clothing, wrongful as that might have been. There was no evidence of all such behavior. Instead, the proof convincingly established and the jury implicitly found that Mr. Trump deliberately and forcibly penetrated Miss Carroll's vagina with his fingers, causing immediate pain and long-lasting emotional and psychological harm. Mr. Trump's argument therefore ignores the bulk of evidence at trial, misinterprets the jury's verdict, and mistakenly focuses on the New York penal law definition of rape to the exclusion of the meaning of that word as it is often used in everyday life and of the evidence of what actually occurred between Miss Carroll and Mr. Trump. Another opinion, Judge Lewis Kaplan ruled, as the court explained in its recent decision denying Mr. Trump's motion for a new trial on damages and other relief in the Carroll case, Carroll 2, based on all of the evidence at trial and the jury's verdict as a whole. The jury's finding that Mr. Trump sexually abused Ms. Carroll implicitly determined, let me repeat that, implicitly determined that he forcibly penetrated her digitally. In other words, that Mr. Trump in fact did rape Ms. Carroll, as the term commonly is used and understood in context outside of the New York penal law. And again, I'm not giving you the Ben opinion, the Popok opinion, the Legal AF opinion, the conjecture. I'm simply reading for you, as we do here, what the opinions say. And I hope you come to Legal AF because you come to us for what the opinions say. Popok, I wanted to give that as background, but I want to pass it over to you to talk about the appeal, how big it was that E. Jean Carroll won this appeal, that it was per curiam. What does that mean? Talk to us about the ruling on the appeal.
Yeah, the appellate issues here are very important, not just for the $5 million judgment about E. Jean Carroll being sexually abused, technically raped, as the judge refers to it, and then defamed. That was the first case that was tried. On the heels of that first case, and that was for $5 million in total. That's the one that Donald Trump didn't testify in. Alina Habba handled. Second trial, right on the heels of that, was not about the sex abuse. It was about, because that had already been determined by the judge to be what we refer to in the law as res judicata, meaning it had already been previously decided by a prior jury or trier of fact. It was fact that needed to be accepted by the second jury, and then the second jury needed to focus on punitive damages and defamation after Donald Trump had already left office in 2020. That's the two different cases, Carroll 1, Carroll 2. Donald Trump testified in Carroll 2, hoping that he would, I don't know, turn the hearts and minds of the jury. And how did that work for him? $83 million judgment instead of a $5 million judgment. And so that also went up on appeal. Appeal's not concluded. It went up first on an appeal related to immunity, because Alina Habba, very late in the game, having effectively waived the immunity argument, suddenly grew a brain and decided to argue that the case shouldn't even go forward because there was some sort of immunity, although he was out of office when all of that happened. So the immunity seemed to be an odd argument to make. And the Second Circuit was like, not only is it an odd argument to make, Ms. Habba, and she argued it, it was also a losing argument because you didn't raise it in time and you waived it. So the immunity issue has already been appealed. He's lost it many, many months ago. He took an emergency appeal or an appeal to the United States Supreme Court, and they haven't done a darn thing with it in over a year. So they're not going to bail him out on E. Jean Carroll 2 or the $83 million. Now he's made arguments about how that case was run by Lewis Kaplan. But now that the 3-judge panel, Chin, and I forget the other two judges, have ruled 3-0. No one takes credit for writing the opinion. It's the opinion of all three of these people, of these judges, and they've ruled that every one of the evidentiary decisions and every one of the that Judge Lewis Kaplan made is really an evidentiary decisions about what we call 415 evidence, meaning evidence about prior sexual misconduct, that Congress has already made an exception to the general rule that you can't use prior bad acts to prove the act that's in the case itself, except in the area of sexual misconduct. And so they said the judge allowed in the Access Hollywood hot mic moment when Donald Trump said he could grab a woman by her P word and get away with it because he's a celebrity, which he doubled down on during a deposition played for the jury, in which he said, yeah, it's been going on for 5,000 years. Yeah, you can grab a woman by our P word, and I'm a celebrity and I can get away with that. I mean, that's effectively his testimony to the jury. And so you have that. And then you had two other women who authentically under oath testified, the jury believed them, that they were sexually assaulted by Donald Trump, one on an airplane and one in a room at Mar-a-Lago during an interview by People magazine. And so they got to testify. That was the heart of there were some other things about, what about the black coat dress and the DNA? And they said, well, you didn't submit your DNA. So that was properly barred from going to the jury. So everything that Judge Kaplan did in his power as the gatekeeper, which is what the trial courts are entrusted with in a jury trial. That's how they keep the wheels on the train in a jury trial. The trier of fact is the jury, not the judge in a jury trial. But the judge has these roles about evidence, but they're given broad discretion in these areas, very broad discretion. Otherwise, you wouldn't be able to get any trial off the ground. There is no. Let me just give our from our own experience. I've been a 34-year trial lawyer. There is no such thing as a perfect trial, and you're not entitled to a perfect trial, state or criminal or civil. You're entitled to a fair and impartial jury. You're entitled to other aspects of due process. But I've never had a perfect trial where there hasn't been an evidentiary issue that was a toss-up, or that couldn't go either way, where the judge, I thought, made a mistake, and then it's up to appellate courts to decide whether these are reversible error or not. And they said time and time again, everything that Judge Kaplan did, they didn't completely agree with every decision, but they said his heart and his mind was in the right place, and it ended in the right place in terms of not being reversible error and allowing in all of that evidence. He's now going to also lose, Donald Trump, the $83 million case, which is going to be before a different 3-judge panel at the Second Circuit Court of Appeals in New York. Could have some overlap in it, but a different 3-judge panel will hear those arguments. But they now know what happened with this particular one. And I'd be shocked if another 3-judge panel of the Second Circuit found any merit to anything Donald Trump has to say about how Lewis Kaplan ran that trial, which means, this is back to the hard rain on Donald Trump, he's going to be paying $100 million, which has been running with interest, to E. Jean Carroll sometime in 2025, whether he likes it or not. And I don't see, even though we're going to talk about our misgivings about this United States Supreme Court, understandable criticism of the United States Supreme Court, I don't see them bailing him out on these particular items about these particular decisions by a trial judge, given what's at play.
Look, when you read the order by the Second Circuit Court of Appeals, one of the things you'll note is that it's per curiam, meaning all of the justices agreed. It was a unanimous decision. And when you look at it, it says, on review for abuse of discretion. That's the standard of review to see, did that federal trial court judge, Lewis Kaplan, whose other opinions I read when I was giving my part of the segment right here, were his rulings, not just on that, but as he conducted the trial, as he oversaw the evidentiary rulings, when people objected, did he sustain the objections? Was there any juror misconduct? Was there anything unfair about this trial? Did the judge, if you think about, abuse of discretion for those who watch sports, right? When the refs go to the instant replay and they determine whether they need to kind of overrule, right? There has to be enough evidence for them to say, you know what, the player's foot was in bounds versus out of bounds. It's a version of that. What the bosses, the Court of Appeals, what they do to the trial court judge, right? They're like the instant replay review, if you will. I'm oversimplifying it, but that's basically what they do. So just imagine, a referee at the football game, if you've been watching the NCAA football, go, on review, we've looked at it. That's what this is. On review for abuse of discretion, we conclude that Mr. Trump has not demonstrated that the district court erred, meaning did not make an error, has not demonstrated that the district court erred in any of the challenge rulings. Further, he has not carried his burden to show that any claimed error or combination of claimed errors affected his substantial rights as required to warrant a new trial. Affirmed. And in my example, you could imagine the referee in the NFL game going first down or touchdown or whatever it is. So that's what took place there. And Popok points out his 34 years of trial law experience. I didn't have as much experience before I stopped practicing, but I practiced for about 13 years. And look, Popok and
including with me.
Including with Popok in a lot of cases, including a case that I see now very, very much in the news on a memorable deposition that you that you took of. People can Google that and look that up if they want to, I suppose. But the point is that these are not just topics that I now teach at USC Law, but when we were practicing lawyers on issues that affected whether it was the Constitution, people's personal rights. I mean, we were in the courts arguing these types of motions, taking depositions, filing appeals, and going through this process. So when we're giving you this insight, we approach it from the practical, the theoretical, the pragmatic, and we try to cover it from each and every side.
We have a full-length podcast. It's called Legal AF. It's been around for 5 years. And it's OG, man. We sit at the intersection of law and politics, so you don't have to. We don't blow smoke or sunshine. If you know about Legal AF, thank you for being part of our audience. You helped get us into the top 10 worldwide of all podcasts in a recent ranking. Crazy. All because of you, for sure. If you don't know about Legal AF and you only know me, Michael Popok, from the work I do on the Midas Touch Network or over on the other channel, Legal AF, the YouTube channel, I invite you to tune into the podcast, take a listen, send that clip off to people in your life and ask them to join our journey as part of yours. So until my next podcaster, Legal AF, this is Michael Popok, and I'm reporting. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.